Nothing on that.
Nothing more, Your Honor.
So the instructions as written are acceptable to both parties. All right. Anything before we bring in the jury?
No, Your Honor.
And counsel, for your own benefit, I instruct all the way through. I stop with the close. I'm gonna instruct. I expect the prosecution will make a closing argument. We'll take about a 10-minute break at that point, and then we'll come back so that we keep the jury interested and invigorated for the entire balance of the trial.
And we are using the projector, Judge, so.
And because I'm going to, once I'm done with the instructions, I'm going to call on you to give your argument. Let's make sure that that equipment is functioning. Is that what you want up there?
Yes, sir.
All right. So, just remind me when you come to do the podium to do your statement. Just remind me to hit the admit to evidence button. All right.
Got it.
All right. Bring in the jury. All righty. The court, you may recall that the court gave you some instructions before you retired for a very, very extended lunch. Did everyone follow those instructions? If you didn't follow them, please raise your hand. Nobody's raised their hand. All right, and just so you folks know exactly what's going to happen, I'm going to read you the closing instructions. And as you probably figured out or will figure out, some of them do mirror instructions that I've given to you before. We know that, okay? So I'm going to read you the instructions. The state is going to present their argument, and then we'll take a 15-minute break. Then we'll come back, we'll hear the argument of the defense and any rebuttal that the state will offer. Then you'll retire to make your decision. All right? That's the roadmap. All right, members of the jury, the court will now instruct you upon the principles of law that you are to follow in considering the evidence and reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law that I give to you in these instructions, applying the law to the facts in this case, which have been properly proven by the evidence. Consider only evidence received during the trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of facts solely as you view the evidence. You, the jury, are the sole judges of the facts. The court is the judge of the law only. The first count charges that the defendant did on Tuesday, June 11, 2024, in the town of Clyman, Dodge County, Wisconsin, did cause the death of Crystal A. Rasch with intent to kill that person and in violation of Wisconsin statute 940.011A, 939.503A, and 973.055 sub 1. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide is defined in 940.01 of the Criminal Code of the State of Wisconsin, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, the defendant caused the death of Crystal A. Rasch. Cause means the defendant's act was a substantial factor in producing the death. Second, the defendant acted with the intent to kill Crystal A. Rasch. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires the defendant acted with intent to kill, it does not require the intent existed for any particular length of time before the act is committed. The act need not be brewed over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all facts and circumstances, in this case, bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in the establishing of guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give to it the weight you believe that it deserves under all of the circumstance. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Crystal A. Rasch with intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count charges that the defendant did between June 12, 2024 and June 25, 2024 in the town of Clyman, Dodge County, Wisconsin, did mutilate a corpse with intent to conceal a crime. This in violation of Section 940.11 sub 2 and 939.503F of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of the state of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with intent to conceal or avoid apprehension, prosecution, or conviction for any crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant mutilated a corpse. Second, the defendant mutilated a corpse with intent to conceal any crime. This requires that the defendant acted with the purpose to conceal any crime, avoid apprehension, prosecution, or conviction for any crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of the offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with caution and care. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence with any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt which is based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of the witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits that the court has received, whether or not the exhibit goes to the jury room. Anything that you may have seen or heard outside the courtroom is not evidence. You are to decide this case solely on the evidence offered and received at this trial. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Remarks of the attorneys are not evidence. If any remarks suggest certain facts not in evidence, disregard that suggestion. Consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by this court. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of the witnesses and the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing the testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the sole judges of the credibility of the witnesses and the weight to be given to the evidence. The weight to be given to the evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even several other witnesses. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether the consciousness of guilt shows actual guilt are matters exclusively for you to decide. Ordinarily, witnesses may testify only about facts. However, witnesses with specialized knowledge in a particular field may give an opinion in that field. In determining the weight that you give to the opinion, you should consider the qualifications and the credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is the duty of the jury to scrutinize and to weigh the testimony of the witnesses and to determine its effect on the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight that you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the results of the trial, a witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice if any is shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and the weight the weight of the defendant's testimony, or the weight that you give to the defendant's testimony that you use to evaluate the testimony of other witnesses. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. Evidence has been received that the defendant has been convicted of crimes. This evidence was received solely because it bears upon the credibility of the defendant as a witness. It must not be used for any other purpose, and particularly you should bear in mind that a criminal conviction at some previous time is not proof of guilt of the offense charged now. Now, members of the jury, the duties. Oh, I just wanted to keep going. All right, Terry Will.
And turn the projector on.
Got it.
Well, good afternoon, ladies and gentlemen, and I just want to thank you all for your attention through this week and 2 days of testimony. I know that you had some long days and a lot of detailed testimony, and that all of you paid attention and took notes, and I know all of the parties here appreciate that, because this is a serious case and these are serious facts that we're dealing with, and this is the case about the death, the killing, the homicide of Crystal Rasch. And the jury process itself is an important process, because defendants have the right to a fair trial. They have the right to 12 individuals hearing all the facts and finding them guilty beyond a reasonable doubt. But victims in this state have rights too, and they have the right to a fair process as well in the state of Wisconsin. So I appreciate all the attention that all of you paid to this case. So I recently had a child that finished kindergarten, and while he was in kindergarten, he got in trouble. And the teacher talked to me sort of in private, and then I went and got him, and I said, hey, heard something happened today. I want you to tell me everything about what happened, from the beginning to the end, and everything in between. And I said, don't leave out any details. And I also said, and you need to tell me the truth. Because here's the thing, when you tell me the truth, it's really easy to tell me the same story over and over again, and tell your teacher the same story over and over again. Because the truth is something that actually happened to you. The truth is something that you actually experienced. But when you lie to me, then you have to remember those lies that you told. And so when you lie to me, I can catch you in that lie, because you can't keep the lies straight between me and the teacher. Sometimes you tell me different lies than you tell the teacher. I also told my child, here's a little hint about your mom. Most of the time when I ask you a question, I already know the answer. Law enforcement is basically the same. When they conduct an interview with someone, they are prepared. They walk into that interview with facts, with information, with documents, with photos, with video surveillance, with bank statements. And then they ask the person a question, and they say, we just want the truth. And they let them talk. And you heard from Detective Cotney that during that interview, he said, this evidence is just the tip of the iceberg. Now, ladies and gentlemen, Detective Cotney wasn't lying in that interview. The evidence that they were showing Zachariah Rasch, that was just the tip of the iceberg. And now you got to see the whole iceberg, the top, the bottom, and everything in between. all of the evidence, not just the evidence that they gathered on June 25th, but all the evidence that was gathered throughout the course of this investigation. And then, of course, you got to hear the defendant's entire statement. So on June 26th, the only person who knew everything that happened to Crystal Rasch, the defendant. So just think about that when you go back to deliberations. To really evaluate this case is really a case of deceit and destruction of evidence. And to really evaluate this case, we have to go really back to December of 2023 when Crystal first files for that divorce. She's asserting her independence. She's taking the steps that she needs to stay in contact with her children. She's putting things into place as that divorce proceeds to sell her house, to move into a low-income apartment. She gets attorney David Lang. So he's representing her in her divorce case, in her child custody case, and her personal injury case. Remember, he testifies about that. That last fact is really important because remember, the very last phone call that Crystal made was on June 10th from her phone in the Adams County area, very close to that property. That was to the attorney, the Gruber law attorney that used to represent her in her civil case, but that represented her and Zach. It's possible that Zach did not know that attorney David Lang took over that civil case. And so he was having her contact the Gruber law attorney. Now remember, attorney Lang testified about her getting her low-income apartment, that she had an optimistic outlook on life, that she was working at maintaining visitation with her children. Even if she was going to lose the case, even if her rights were getting terminated, she was working on maintaining that visitation with her children. She was maintaining contact with her children. She was seeing her children. She was text messaging with Heather Doherty about her children. Heather was keeping her in the loop, and Heather had no intent to cut Crystal out of her children's life. Then you also heard from attorney David Lang that him and Crystal had a good relationship, that she messaged him, and that he never received any correspondence from her firing her until Zach's attorney forwarded an email that was sent in the middle of the night at 1 a.m. on June 12th. And that message was actually from Zach, firing attorney David Lang, but he sent it to the wrong email address. That's the only time that there was ever any indication that attorney David Lang was going to be fired. So then you heard from Heather Doherty. She talked about how Crystal rarely missed her visits with her kids, and how on June 10th, she told her that she wasn't going to make that visit, and she sent her a picture of her son's kindergarten graduation. And this is the type of thing that Crystal would always respond to, but she did not respond to that photo. And she never heard from Crystal after that point. Then you heard from Diana. She told you that the last time that she saw Crystal, sometime around June 6th or June 7th, it was the happiest that Crystal had ever been. She was moving her stuff into storage. She was getting ready to move into the low-income apartment. Her dad was helping her. They had recently reestablished communication over Christmas. You heard from Robin Reels about getting that fake Facebook message, and Robin said that she did not like it when Crystal was spending time with Zach, and I think she testified something to the effect that she didn't like the way that Zach treated Crystal. I don't know what the defense is going to say in closing, but I'm sure they'll make reference to the fact that Crystal kept her relationship with Zach and the fact that she was seeing Zach a secret from her friends. But even the defendant testified on the stand that her family didn't like him, that her friends didn't like him. I think he mentioned one friend that actually liked him of crystals, but nobody else liked him. We don't have information of why that was, but just from the evidence presented in this case, we know that he lies to his children about things, he lies to his mom about things, and he lies to law enforcement about things. So maybe it was just that he lied to Crystal about things. So after the divorce is filed, according to Zach's statement, he says everything is fine. The divorce doesn't bother him one bit. Nothing changes. Everything, everything's the same basically. Except for his internet history tells us a different story. And some of the facts within his statement tell us a different story because we know he has to move out of the family home. We know that that is a fact. He has to move back in with his parents. And then we know starting in February of 2024, he starts researching cheating spouse in divorce. So that's on February 2nd. Then February 20th, he looks up another civil case involving him and Crystal. And then he researches and ultimately on February 20th, purchases a firearm and also starts researching silencers. Now, even in his own testimony, he says the last firearm that he owned was back in early 2000. Detectives testified they did not find any other firearms in that home. I'm cognizant we're living in Dodge County. It is certainly not unusual for someone to own a firearm in this county. But rely on your own common sense. Someone who's 42 years old and purchasing a firearm for the first time in about 20 years, what does that say about the person when they're researching that in correlation with the searches related to cheating spouse in divorce and other cases on the Wisconsin Circuit Court access related to their wife? Then he has searches on the 21st of February. How can I disguise my voice? February 24th. How long will fingerprints last on a plastic surface? Then he researches cameras, whether a spouse can install cameras, and whether you are allowed to install hidden cameras. Then he starts researching whether you can find someone's location on Facebook. That's the same day that he's researching about cameras and divorce. Then moving to March 30th, he goes on from researching someone's Facebook location to researching whether or not you can get someone's location through their cell phone. Clearly attempting to track somebody's location. We don't necessarily know who, but the very next day, he looks at the satellite view of 730 Main Street, his former residence and the residence where Crystal Rasch is living. Then on April 4th, he goes into a lot of research on IP addresses. So now he's trying to hide his own identity, trying to figure out how law enforcement can track IP addresses, whether or not they can locate someone else, whether they can locate someone's location using their IP address, if they use a Wi-Fi hotspot, if their phone is off, if it's not accessing the internet, all of these searches. He gives some explanation on the stand. You are the ultimate individuals who are going to judge his credibility. You get to make the determination of whether or not his explanation makes sense. Just the sheer number of IP address searches on that date, the state's opinion is significant. So then we move to April 8th. Things are starting to get more significant now. We have at 12:37 a.m. So remember his work schedule. He works from 2 to 11. So 12:37 is probably after he's getting off of work. I don't know that for certain. I didn't look at April 8th to see whether or not that was a work day or not, but we know that he's sort of that, I believe that would be considered second shift, that 2 to 11 shift. So he stays up in the early morning hours, and now he's searching at 12:37 a.m. The family law case, and then at 3:31 silencer, 3:34 home built suppressor, 3:35 how to make a suppressor, 3:37 how to make a silencer for a 9mm. Again, he gave an explanation. You're the ultimate judges of credibility. You're the ones that get to decide whether or not that explanation makes sense. But use your common sense and life experience. What does it say about a person who's researching their cheating spouse, researching finding someone's location on Facebook, researching trying to track someone's location using their cell phone, researching purchasing a 9mm, purchasing a 9mm, researching the family law case, and then a silencer? Also, we're not talking about a rifle. We're talking about a 9mm. What would you use a silencer for on a 9mm except for some type of nefarious purpose? April 12th. Now we see at 5:10 p.m. he visits the family law case, and then later that evening, can a person feel when they are dying? At this point, the defendant's thoughts are on display via his internet searches. This is what we call planning, premeditation. He's thinking out what he wants to do with his wife. Now we move into May. Remember his own testimony that they were up in Adams County in May. So he searches where to get ammunition in Adams County. Then on May 28th, searching, gunshot wound to the head. This is planning, premeditation. Now we have gone to just thinking about it to really developing a plan. How am I going to shoot her in the head to make it quick and a fast death? Gunshot wounds to the chest. Again, this is all well before she gets shot. This is well before June 11th. The defendant gets up on the stand and says that he was thinking about committing suicide because after 5 years of not seeing his kids, he's so distraught about losing them. But remember the testimony from the social worker, Miss Gordon. The defendant called on June 10th and said he was going to terminate his parental rights. And then on June 17th, 6 days after Crystal dies, he goes into court and terminates his parental rights. He had only seen his children one time since proceedings were initiated. This is not some man who is agonizing over the loss of his children. This is someone who is planning the death of his wife. I think also we have here, will a gunshot wound to the head instant death? Instant death. Again, same time frame, 12 a.m., 12:40, 12:41, 12:45 a.m. Early morning hours, that time where he's stewing, ruminating about his feelings for Crystal, all on full display on his internet searches. Will a 9mm kill an animal if shot to the head? I know the defense might get up here and give an explanation that he was truly searching about shooting an animal. This is a description of what will happen when you shoot someone in the head and how quickly they will die. June 6th. 5 days. 5 days before Crystal dies. How long can you get widow's benefits? Can you get widow's benefits if taxes were never filed? 11:26 p.m. and 11:30 p.m. Again, I know that the defendant said, well, I was looking for Brenda. There's no evidence that the two of them were even together, that Crystal and Zach were even together on June 6th. And after Brenda's been living there for 2 years now, all of a sudden he's making these searches. There's no evidence that he ever searched this information before on behalf of Brenda. This is about him and Crystal. He's not a widow yet, but he's about to make himself a widow, and he's looking to see if he can benefit financially from that. And turns out, as we know from the evidence, he will benefit financially, at least for a short period of time. So now we also know, we don't know if he's with Crystal, but Diana talks about seeing Crystal around this time. So for all we know, on June 6th, Crystal is actually with Diana, her stepmom, and her father at this time. Now on June 7th, we have Crystal going to the Piggly Wiggly. She's alone at this time. Then on June 8th, that's when we see that video surveillance at 11:40 a.m. that Detective Conkle testified to, where you can see her walking down her driveway and climbing. Likely, this part of Zach's story and his interview is correct, that he does in fact pick her up from the church, probably because Crystal doesn't want Brenda, her mom, to know that Zach is picking her up. And it's likely that Zach does in fact pick her up in the church parking lot sometime around noon. But that video surveillance at 11:40 a.m. from her house is the last time that Crystal is seen alive in Kleiman, Wisconsin. That's June 8th. Now, we then see the vehicle traveling up on Flock to the Adams County area on June 8th. We see lots of Flock hits on Flock hits on June 9th. Nothing on June 10th, but likely still in the Adams County area, Wisconsin Dells area. And then in the evening of June 10th, 11:49 p.m., again, that same time period where he's making all of his other searches, he's Googling child custody attorneys in the Milwaukee area. June 11th, he Googles at 10:41 a.m. How to get to Milwaukee without interstates. And then June 11th at 11:18 a.m., I guess that coyote search. Will a 9mm kill an animal if shot to the head? He says coyote. I say planning, confirming what he should do. So our evidence has them leaving Adams County in the early morning hours, traveling down to the area of Oconomowoc. Then we have our Culver's video where we see Crystal and Zach together purchasing, here it just looks like drinks, likely also food at Culver's. Zach is wearing that Silverado shirt, and Crystal is wearing that Wisconsin Dells sweatshirt. We believe that's around 10:27 a.m. That purchase is with Zach's card. Then we have the Goodwill footage. This footage here, right here, June 11th, 2024. That is the last time that Crystal Rasch is seen alive. Walking out of Goodwill, thrifting, one of our favorite things to do, with her estranged husband, Zachariah Rasch. We then know that she gets to the back of that vehicle. She changes her shirt. He says standing outside, and that's probably correct. I don't have anything to disagree with that, but there's an indication that she's changing her shirt. We actually find that Goodwill tag and the sweatshirt in the back seat. Now, of note, remember all of those pictures from Trevor, I believe it's in the lead, how you say his last name. No blood in the back seat. No blood in the driver's side. Only blood in the passenger side seat. So the next search here, again, 11:18. Will a 9mm kill an animal if shot to the head? So they get in the car from the Oconomowoc Goodwill. Defendant's story: she wants to go to Milwaukee to look for child custody attorneys. Or does he want her to go to Milwaukee to hire a new attorney to dismiss the divorce? Does he want her to choose him over the children? Does he want the divorce to be canceled so he can get his house back, so he can get access to her money that is in her bank account? The only evidence that we have of anybody searching child custody attorneys is the defendant. We don't have any evidence that Crystal ever did that Crystal ever had any desire to search for child custody attorneys. So then we have the phone go down to the Milwaukee area, goes down to the Greenfield area, and then I know the defendant couldn't remember if he stopped at Speedway before or after, but then can tell you they were in Milwaukee about 10 minutes before 2, and then we have him on video at that there's another stop in the area of New Berlin, and then they head up back towards Clyman. So then we have the defendant's version of events. So he's driving up, it's silent in the car, they're listening to the radio, can't remember which station, and sometime on Highway M, after they get out of Watertown, he doesn't see her reach into the console, even though he's sitting there driving, center console's right next to his left arm. He doesn't know when she reaches in, doesn't know when she gets the gun, doesn't know when she takes the gun out of the holster, but at some point she's got the gun on her lap, doesn't say anything, and then puts it up to her right side, pulls the trigger, and then he just doesn't know what to do. He just keeps driving. He keeps driving there on Highway M, drives back to his house, gets to his house, just stands there, pulls her body out, puts it in the grass, takes the gun, puts it back in the holster, the gun that just put a bullet in her head and killed her, but has no blood on it, her hand that has no blood on it, even though the vehicle is so saturated with blood that when he cleans it with that Hoover vacuum cleaner, that the crime lab can still find the defendant's DNA both on the lip of the vacuum cleaner and in the actual hose, even though there's water and detergent flushing through both of those items. That's how saturated with blood that vehicle is, but no blood on the gun, no blood on her hand, according to the defendant. And then, really, I think the most important response, how did it get the other bullet put back in, right? Detective Casey Young testified it was a loaded handgun, fully, the magazine, the gun was loaded. There was a bullet in the chamber and magazine fully loaded except for the bullet in the chamber, and he unloaded, took the bullet out of the chamber, took the magazine out, made the gun safe. If she shot herself in the head, there should have been one bullet missing. If he did nothing with the gun but put it back on the TV, there should have been a bullet missing. That's the thing. When you're not telling the truth, you mess up facts. Because if it didn't really happen, you can't get the facts straight. So when someone asks you a specific question about the facts, then you can't think of a quick answer because you're not talking about what really happened. I don't know what really happened. I have no idea. I wasn't there. But the evidence tells me that there's blood on the passenger side door. There's blood on the passenger side window. There's dripping blood down the door. There's blood in the vent. Her seatbelt is still on. We know that she liked to be dropped off at the church. We know that he took her down to Milwaukee to attorney's offices. We know that she never tried to fire her attorney. We know she was planning on following through with the divorce. So perhaps, based on the evidence, they got back to his house and he said, "Get out of the car." And she said, "No." And he said, "Get out of the car." And she said, "No. Take me back to the church. Take me back to the church. Take me back to the church." And he stood there from the passenger door and shot her in the head. And then she slumped over and bled out. And then he pulled her out and took her to the burn area. So when he repeated over and over and over again in his interview that she was at the church, that he dropped her off at the church, the reason why he kept saying that is because that's what she kept asking for at the very end. I don't know that for certain, but based on the evidence, that's possible. So now let's talk about his panic. So he burns this body in 4 hours. His body covered with flesh and fats and thick bone that Dr. Jordan Carson, the anthropologist, testified that the bone would have to be crushed. Remember, we didn't find significant thigh bone, arm bone, hands, feet, none of those things. But he burned most of the body in 4 hours, according to his testimony. So while he's in a panic, what does he do? 8:17 p.m., June 11th, his son, Zach Jr. Remember, nobody's calling the police now. Nobody knows that Crystal's missing. Have you heard from Crystal? Nope. Okay. Seems like someone in a panic to me, I guess. Then, to his daughter. So this is UTC, so 7:31 p.m., so about an hour before his son. Have you heard from Crystal? No, I have not. So now his lies that he's going to start, he's roping in his son and his daughter. So then, in his panic, I'm so panicked. What do I do? My wife, the woman that I love, just shot herself. I'm not going to call police. I'm not going to take her to the hospital. I'm not going to call 911. I'm not going to see if she can be saved or if she's still alive. I'm going to burn her body, and then I'm going to send these messages to make it seem like, oh, she's missing. And then I'm going to take her debit card, go up, take her farmers and merchant card, pull money out of that account, and then take her Bank of Lake Mills card and pull $200 out at Quick Trip. because I'm so panicked. I got to get my first $300 from her bank account. And then, in my panic, in the early morning hours, going to send this message to Janet Brown, from all accounts a person that Mr. Rasch has never met, and through the early morning hours, into the early morning hours of June 12th, it's going to say, I'm looking for a serious relationship. And you? Now he says when he testifies, just looking for friendship. But still, even if you're only looking for friendship, when you're in a panic because your wife just killed herself, you're going to go on Facebook and start messaging complete strangers? The other things that he does at this time, he made a payment towards a Capital One credit card. He pays off his Mitsubishi Eclipse, $1,500. He starts researching the Kelley Blue Book value of his Ram because he can't drive that Eclipse anymore. It's covered in blood. And I just wanted to circle back to the gun one more time because I don't want to forget this. Because he says it's not, I understand he says he doesn't clean it because it's not covered in blood. But just think about using your common sense. Is it reasonable that a gun that's used to shoot someone in the head has no blood on it? When it's dropped to the passenger floor and then blood starts pouring out of that person. Just use your common sense. Now going on to June 13th. He starts researching cleaning supplies at Menards, Dirt Devil, portable carpet and upholstery spot cleaner. Do raccoons eat bones? I never actually heard an explanation for that search during direct. And I conveniently forgot to ask about that one. I'm going to tell you, I think we learned from Dr. Carson that unfortunately raccoons chew on bones, but they do not eat bones. I guess we don't know for certain that this was a raccoon, but a carnivore, but they could possibly dig up the bones. Next slide, please. Now on the 14th, we have him at Quick Trip, continuing to pull out more money, $200. And you heard, I believe it was Detective Lake, testify that the max amount that you could pull out of the ATM, $200. So every time he went, he pulled out the max. June 15th, Menards. Here, now, we start with Santeen drain opener, concentrated sulfuric acid. Now he's buying gloves. Now he's buying the cleaner, the spot remover, the OxyClean wipes, the air freshener, and of course, a monster, because he's got to make sure that he keeps his energy up for the task at hand. So you get to decide based on your common sense and the jury instruction based on credibility, does it make sense that he only burned this body for 4 hours on the 11th, or did he start burning it and realize this is not as easy as I thought, and he went and started pouring sulfuric acid on his wife? His wife, the mother of his children. June 15th now, 5:23 p.m., Harbor Freight, socket set. He never admits this, but likely to remove the seat from his Eclipse. June 16th, we have him, Blaine's Farm and Fleet, black and blue storage tote with, so a 27-gallon storage tote, which we never located. And then the Arm & Hammer laundry detergent. That was the Arm & Hammer laundry detergent that the crime lab found blood on the handle but did not come back positive for DNA. And remember the testimony there that the detergent can break down the DNA, but not in the vacuum, not in the Hoover vacuum. That's how saturated with blood it was. June 16th, Ace Hardware, 4 bottles now of 32 ounces of Santeen industrial strength liquid drain opener. Sometimes we're saying Drano, or during the interview Drano, because that's what people can associate with drain cleaner. This is not Drano. This was extra strength sulfuric acid drain cleaner. June 16th, Walmart Supercenter, more cleaning supplies. June 18th, maximum amount $200 ATM withdrawal. Also on the 18th in Beaver Dam, he's got his oil filter supplies, and then OxyClean, cleaning spray, Armor All wipes, his beach towel, Mario beach towel that he talked about at some point during his interview, and then Walmart Beaver Dam, the tires that he talked about during the interview, that then he admitted on the stand here today that he didn't actually have consent to purchase from Crystal. Then the 19th, the transaction from the DMV in Watertown, registering now that red Chevy Cobalt. And then also on the 19th, he had a transaction at Walmart and then got $100 cash back from Walmart. Going on to his internet activity on the 19th, now searches for a replacement passenger seats at 12:57 p.m. and 12:58 p.m. To replace the front bucket seat of the Mitsubishi. On the 20th, also goes to Farm and Fleet, getting a Monster, more OxyClean, then O'Reilly, the purchase of those LED headlamps, and then on the 20th at 10:30 a.m., the $200 ATM withdrawal. On the 20th, also significant, now he's messaging a woman that I believe that he just starts out with, "Hi, long time, how you fooling," but I think that's from Arlene, so some indication at least that they may have known each other. And then he says, June 20th, again, this is before Crystal is reported missing. Nobody has reported her missing to law enforcement. Living the single life. Yep, I'm single. She cheated on me while I was at work. Don't know, been single and looking. And then he asked this person out. Seems like looking for a little bit more than friends here. Seems like maybe, I guess this is someone that was in a panic about his wife killing herself or accidentally shooting herself. Now we go to June 22nd. Can you clean a vehicle interior with cold water? Now at 3:56, do possums eat bones? On the 22nd at 5:55 p.m., we have more purchases of that Santeen drain opener, now from Menards and Johnson Creek. On the 22nd, we also have a purchase, according to the bank accounts, from Tobacco Plus at the Vape Place. He does admit to that on the stand here today and talks about that during his interview. On the 22nd, another purchase at Walmart in Watertown where he gets cash back. Now on the 23rd, he goes to Beaver Dam, gets some more Armor All wipes, air fresheners, got to get the Monster, and then goes to Menards and Beaver Dam, gets 6 32-ounce Santeen drain opener bottles. So in total, we track 14 bottles, 3.5 gallons. I guess it could be that he's just pouring it on the fire pit, the surface burn area afterwards, or he's trying to break down that body faster because it's not quite as easy to burn a body as he thought, using sulfuric acid to destroy, mutilate his wife's body. Now the 23rd, 6:29 p.m. If you remember the interview, I'm not going to say the quote, but Detective Rolfs does make a quote about what might be going through his head when Deputy Kukan comes rolling up. But we'll just play this portion of the video briefly here. This is the squad camera video that we saw at the very beginning portion of the trial. So this is Wood Road coming up on his residence. He walks up, walks from the burn area. This is the eclipse right here. So walks from the burn area, walks away, closes this, doesn't close these doors, closes this, and then walks up to the deputy. So remember, this was enhanced, and we could tell there's smoke coming from this area. Defendant says, I was just burning garbage. Based on all that I've learned about Crystal, I do not think that she was garbage. She seems like a very kind woman that loves her children very much. Based on his behavior and his actions, apparently at this point, that's all he thought of her, is that she was garbage. He was burning her, mutilating her. So now, the 23rd. Okay, so this, 6:29 p.m. 6:29 p.m., June 23rd. 6:42. Is sulfuric acid flammable? What happens when you add gas to sulfuric acid? So now, whatever was soaking in that sulfuric acid, he needs to start burning faster, because now he knows that Crystal has been reported missing. Now he knows that the law enforcement is looking for her, and he doesn't know whether or not that deputy noticed the fire burning or not. So at 7:14, can police get a warrant on Sunday in Wisconsin? How fast can police get a warrant? Then, June 24th, drives that vehicle up to the Adams County property. And remember how little he thought about Crystal. That he took some ridiculous green frog. You're probably thinking, why is the state admitting this green frog into evidence? Because of the sheer ridiculousness that the seat that his wife died in, that when he drives the vehicle up to Adams County to hide the evidence, to hide the where she died, the scene of the crime, he puts some stuffed green animal in the seat and then hides up to his grandparents' property, where they would go to spend time, to relax, to enjoy themselves. Then he comes back down, gets back home to the Wood Road property, and visits what chemistry reaction will happen if I mix petrol and sulfuric acid. We know from testimony that petrol is another word for gasoline. Then on the 25th, he searches Wisconsin missing person alert, missing people in Wisconsin, active missing persons near me. And then we know shortly after that, law enforcement makes contact with him and he is interviewed. And I know you were all listening during the interview, and it was long portions of the interview, and I'm not going to go through all of the parts of the interview. But think about the lies. It was full of lies. He lied about what date he went to the Dells. First he said he went just for one day. Then he said for one night. Then he finally admits 2 nights. But remember, he only admits the timeline of events when he is confronted with the actual evidence. Law enforcement knows the answer to the question before they ask the question. But they let him talk and talk and talk and talk and bury himself in his own lies. Then he lies about what vehicle he drove up there. He said that he's driving that blue Dodge Ram. Why would he lie about that? Because he knows that the Eclipse is the scene of the crime. He lies about this fake Facebook account. She's messaging me from this fake Facebook account. Where is Crystal? I don't know. I'm dead honest. I don't know. What did you do to Crystal? I don't know where she is. That's not what we asked. What did you do to Crystal? I don't know where she is. I tried to keep track of how many times he said that phrase. I could not keep track. He lied about going to Menards. He lied about going to Harbor Freight. He lied about going to Ace Hardware. I mean, just think about the ridiculousness of someone who lives in Dodge County lying about going to Menards. He lied about going to Farm and Fleet. He lied about having family land in Adams County. He lied about even owning the Eclipse. He lied about where he was. He lied about when he worked. In the beginning of the interview, they said, all we want is the truth. Detective Cottony said, this is your fork in the road. The defendant took the wrong fork. He took the fork of deceit and destruction of evidence. Do not let him get away with his lies. The final. So this is called the homunculus. And I kind of practiced that word a lot. This was created by Dr. Jordan Karsten. So this first one is all the bones that were found. Remember, the yellow were the ones that were not burnt, and the purple were the ones that did have charring, were burnt, and then these dark ones were the ones that were very burnt. So the yellow ones were the ones that had to get rid of when he was interrupted. And what did he do? He probably dispersed some in that heavy green foliage, and then he buried the rest. He buried the rest in that shallow grave that we located in October of 2023. Next slide. All of these bones from the skull, many of them that Dr. Karsten testified were all, said, I'm not going to use the fancy term, were broken around the time of his death. So all the injuries from the skull that were the breaks from a result of when he shot her in the head, he was not able to destroy that fast enough. So he had to throw those bones because it was not as easy to mutilate and burn and soak with sulfuric acid Crystal's body as he thought. So again, ladies and gentlemen, at the conclusion, when you retire to that jury room, I'm going to ask you not to believe the deceit, not to believe the lies, and to find the defendant guilty, first-degree intentional homicide, and mutilation of a corpse. Thank you.
Thank All right, ladies and gentlemen, the 15-minute break I promised you is going to be a 10-minute break. There you go. And but remember, you still need to hear some additional argument from the defense. Out of fairness, please keep your duty to not discuss this case. We'll take 10 minutes. We'll see you back at 2:20.
They don't hold up that